that they have met their burden.
A big surprise at the Barnes Foundation Museum in Philadelphia. They have found 2 unfinished sketches by Cezanne, not seen since the early 1900s. They were found on the reverse side of 2 of his watercolors during conservation work. Officials at the museum say Dr. Barnes was probably not aware of their existence. The sketches will be displayed in double-sided frames in April and May. This is CBS News.
Hey neighbor, Ace's 20% off store-wide sale is this Saturday only. So stop by your neighborhood Ace to get 20% off almost anything store-wide that you can fit in your bag. From paint to birdseed to light bulbs. It's our way of saying thanks for being great neighbors. Offer good at participating Ace stores only. Discount applies to the regular price of in-stock merchandise that fits inside one bag. Additional conditions and exclusions apply. See store for details. One bag per customer.
Ace is the place with the helpful hardware, folks.
Where do you think the strongest muscles in your body are? Abs? Biceps? They're in your eyes. But using a computer can strain them, causing headaches. Now, think about this. Your eye doctor has new technology to combat that. Isn't it time you thought about seeing an eye doctor yearly? Find a Think About Your Eyes doctor near you at thinkaboutyoureyes.com. And keep those muscles feeling fit. Brought to you by the American Optometric Association.
It's a mystery worthy of a very famous detective. CBS News correspondent Larry Miller has the story from London.
A long-lost Sherlock Holmes story has been discovered in a Scottish attic 111 years after Sir Arthur Conan Doyle wrote it and 80 years since the intrepid sleuth's last caper. Conan Doyle wrote the short story to raise funds for a bridge lost in a flood. In the Book of Brig, Dr. Watson can't join Holmes on a baffling case because he's going elsewhere. Holmes uses his deductive skills to figure out Watson is at the bridge fundraising event, which in fact was opened by Conan Doyle. Larry Miller, CBS News, London.
The gumball bandit being put in a police lineup in New York today. Cops say Jason Beach is suspected of stealing more than 100 gumball machines in the city. The New York Daily News says his license plate reads GUM. No word on what Beach will do with all that sticky stuff. Deborah Rodriguez, CBS News.
Private mortgage insurance, or PMI, can cost you thousands. But with the PMI Advantage from Quicken Loans, you may never have to pay those expensive monthly mortgage insurance premiums again. Hi, I'm Jay Farner, president of Quicken Loans, and I'm excited to tell you that the Quicken Loans PMI Advantage is our lender-paid mortgage insurance program. You see, we pay the PMI so you don't have to. Make the smart call and talk to one of our home loan experts today at 800-QUICKEN. You'll learn how the Quicken Loans PMI Advantage can give you more options, more flexibility, and may save you thousands when you refinance. And for 5 years in a row now, J.D. Power has ranked Quicken Loans highest in the nation in customer satisfaction. And this year, for the first time, they've also ranked us highest in mortgage servicing. To learn more, call us at 800-QUICKEN. That's 800-QUICKEN, or visit us at QuickenLoans.com.
Visit jdpower.com for award information. Important terms and conditions apply. Call for cost information. Equal housing lender. Licensed law 50 states and MLS number 3030.
Good afternoon. This is George Yates, and the show is Justice for All. And we're going to be here the next couple hours, and we're going to do just a bunch of things we're going to be talking about today on the show. We don't have a guest we don't have a guest author today, so we're going to be just talking about a bunch of different things in the news, and it's all really going to kind of revolve around guilty pleas and sentencing and criminal defense, and how do people come into court and plead guilty to crimes perhaps that they didn't commit, and what is it that people do, and why do people go plead guilty to a crime, and why do they go to trial on it, and so on and so forth. And, the first story we got to talk about is really the Mcdonald trial, because Maureen McDonald was just sentenced yesterday, and I'm here in the studio with my producer, Greg Hall. How's it going, Greg?
It's going great.
And we've got Dee here, too, the engineer. How you doing, Dee?
Doing pretty good.
All right. So anyway, we're going to have a little three-way conversation here about things that are going on in the news. Greg got me all these topics here today because, as we were getting ready for this week's show, he was saying, man, we need to talk about people that, plead guilty to crimes they didn't commit. I go, well, that doesn't happen a whole lot, but it does happen. Most of the time people plead guilty because they are in fact guilty, and they get a better deal by pleading guilty than by pleading not guilty, as a matter of fact. The first thing that comes to mind, though, is the Maureen McDonald sentencing yesterday. She got a year, and Bob McDonald got the 2 years. And I guess they're both going to appeal. And Bob was able to stay out on bond, I guess, while he's going to appeal his conviction. But what's interesting about that case, especially with some of these other topics that we're talking about today, Greg, is that the McDonald's got sentenced, and a lot of people don't think they should get any jail time. And she's got a year. But, ordinarily in the federal system, you get penalized if you go to trial. And in this case, the McDonald's went to trial, and it didn't really get hit that much harder than they would have gotten had they just come in and pled guilty. In fact, they probably did better by going to trial, and that is unusual. Most of the time when people come in and plead guilty in federal court, it's because if they plead guilty to the charge, they might be looking at 3 to 4 years under the guidelines. But if they plead not guilty and take a trial, they could get 10 or 12 years just because they get hit for going to trial. They might get extra penalties because if they testify and they're found guilty, they get hit for extra points for perjury and that sort of thing. So, that's what we're talking about today.
What's a trial penalty? I mean, you get penalized for taking advantage of your right to a trial?
Yeah, I mean, in general, that's what happens. And that's why the whole federal system, and today we're talking about really two different sets of types of trials. And we're going to start, I guess, with the federal system. You get penalized by going to trial in federal court, for sure.
So so by not taking the plea or whatever and going to trial, they factor in, hey, you're causing us this much time and cost, and we're going to penalize you.
Yeah, I mean, it's just the way prosecutors approach cases. If and the way the system is set up now, with the way we've got these mandatory sentencing guidelines, they're now no longer mandatory. They used to be mandatory sentencing, now they are advisory. But judges still do follow the sentencing guidelines. What's interesting about the McDonald case is that the judge didn't follow the guidelines in that case. I mean, Bob McDonald's guidelines were somewhere out about 8 years, and he gave him 2. And Maureen's were somewhere between, 5 and 7, something like that. She got 1. So this judge, Spencer, went down from the guidelines, which is, more and more judges are going down, departing down from the guidelines. And they can do that now. But for years, judges had no discretion in departing downward from the guidelines unless it was followed a formula. For many years, judges had no power really in the federal system. And that's what's happened over the course of years, and a lot of people complaining about it. Jed Rakoff, who's a federal judge, we've got some articles that he's written here, and he's a federal judge in New York, and he doesn't like the fact that prosecutors now have all the power. If a prosecutor wants to prosecute you, let's say for cocaine sale, and it's a certain amount, you're going to be looking at a mandatory minimum of 10 years. And if you go to trial on that and you are convicted, you will do at least 10 years or more. If you plead guilty to it and agree to plead guilty to it early on, the prosecutor might come to you if you're the defense lawyer and say, okay, I'll tell you what we'll do. If he wants to come in and plead guilty to it, we will stipulate that the amount that he was selling was less than 5 kilos. Because you got to have a certain amount in order for you to hit that mandatory minimum. If it's less than 5 kilos, then it's going to be less than that 10-year mandatory minimum. So the prosecutor is the one that's driving the entire sentencing process, not the judge. It's the prosecutor. The prosecutor can say, okay, Greg, you're the lawyer. You're going to say, okay, I'll tell you what I'll do. If your guy wants to come in and plead guilty, we'll stipulate that he was only selling 4 kilos instead of 5.5. And that means that he's not looking at 10-year mandatory minimum. He might get 6 or 5. And if he cooperates, gives us information that leads to us arresting or prosecuting somebody else, he can knock his sentence off another 20, 30, 40, or 50% because he's getting substantial assistance and he gets cooperation points. So a guy that goes to trial isn't cooperating, right? So he's going to get at least 10. If he takes the stand, and he says that he didn't do it, and the jury convicts him. Well, he picks up extra points because they're going to say, well, that's obstruction of justice because he testified and the jury didn't believe him, so he must be lying. Let's add on some points. He doesn't get all those, these nice points for cooperating and admitting responsibility. So he's going to get 12 years, okay, if he goes to trial. That same guy comes in and cuts a plea bargain with the Commonwealth, or the government in this case, federal government. Federal government says, all right, we're going to knock the amount down from below 5 to 4. Now you're not looking at the mandatory minimum. And do you know anything? That goes, yeah, I can tell you the names of this person and that person and this person and that person. All right. So they completely debrief. Now he's doing 3 or 4. And since he's a drug defendant, by the time he goes in, he might get some credit for that. And so on. He goes into some kind of rehab as part of the federal sentencing. So instead of doing 12, he does 3. And that's the system all the way out. The average drug defendant in America gets about 5 to 5.5 years if he pleads guilty. And if he goes to trial, he gets about 15.
Wow, that's a huge difference.
You have to plead guilty. And that's why 97% of all federal defendants are now pleading guilty. And that's why the McDonald's case is so interesting, because they went to trial. And in fact, and this trial defense that they had, I'm not sure everybody believed that the McDonald's marriage was as bad as it really was. I mean, apparently, that was the defense, that Maureen was this real battle axe and she was painted really badly, and they really threw Mama under the bus and her off the train. And as I say, and even Spencer from the bench yesterday said that he really didn't believe the story. I thought that as they came out with this story, as it was during trial, and I commented on it, that it just didn't really pass the test. I mean, the McDonald's broke up, I think, a week before trial. They'd been living together right up until a week before they went to court. But the judge didn't penalize them for that. There's so many people that do go to trial, and then after trial, the judge, while he's doing sentencing, is going to say, well, I think you perjured yourself when you testified. That's obstruction of justice. I'm adding on some points. You didn't admit responsibility. I'm adding points on for that. The guidelines call for X amount of years, and I'm staying within the guidelines. You're getting 8 years. Goodbye. But he didn't do that with McDonald's. He didn't penalize them for going to trial, and that's unusual in the federal system. And that's why when we started talking earlier this week about why did innocent people plead guilty? Okay, because they don't want to go to trial, because there is a trial penalty, and there's no doubt about it that in federal court you get a benefit by pleading guilty as opposed to going to trial, and that's why very few people go to trial anymore.
So is it a negotiation process between the prosecutor and the defense?
Well, it's always that way. I mean, and the thing of it is that the prosecutors hold all the cards. What's happened in the federal sentencing scheme in the last 30, 40 years, where it used to be many cases went to trial. 20, 35% of the cases used to go to trial. There used to be a lot of jury trials back in, let's say, the 70s and 80s. But the sentencing guidelines came in around 84 in the federal system. And right about that period of time, Congress was imposing a lot of mandatory minimums on certain kinds of crimes. We know that ever since Roe v. Wade, and you mentioned the Rockefeller Commission or whatever it was. Remember, Roe v. Wade in 1973, was it? And Roe v. Wade was the decision that gave the right of abortion, and a lot of conservative activists didn't really like that. Okay, they thought that was too much judicial activism, right? And I don't know if it began necessarily with Roe v. Wade, but the Warren Court before that, establishing the right to counsel, the Gideon v. Wainwright case, and the Miranda rulings and all that sort of thing. Those were decisions made by judges which gave rights to individuals. And I think that as Congress began to look at this situation, they wanted to take more and more power away from judges. And we saw this happening. They would say, okay, if you get convicted of this particular crime, you're going to do a mandatory minimum. Well, now the judge has no power. Imagine that you are a judge, you're a federal judge, and you now have a person in front of you that's been found guilty of this offense or has pled guilty to this offense, And you have to give him a certain amount of time. You can't go down. You have to give him 10.
Regardless of circumstances.
Exactly. So what has happened? What happened? Well, the legislature basically said, sorry, judges, we don't trust you. We're just going to say you can't be a judge. We're going to take this away from you. There's many judges that have complained about, federal judges and state judges too, because there's mandatory minimums in the state court too. You possess a firearm in the commission of a felony, you got to pull 3 years, mandatory minimum. You possess if you're a convicted felon in possession of a firearm, you got to pull 2 years, no matter what. There might be a judge that says, I don't want to give him this. I don't want to give this guy the 2 years. He has to. So prosecutors in the state court also have a lot of power in those charging decisions. A prosecutor can say, in fact, this will happen. I had a case recently where I had a client that had a gun. He had a conviction. You try to go to the prosecutor and say, wow, he's got to pull 2 years on this. The prosecutor says, sorry, hands are tied. Office policy can't break this charge down. And if the office policy says, well, in certain cases, we don't have to prosecute, we can drop this gun charge and let him plead to something else and do less than the mandatory minimum. It's a charging decision. It's a decision. So prosecutors now have most of the power in the federal system, and more they're having power in the state system because we're putting these mandatory minimums in place.
Wow. So, in your experience, I mean, has this really changed the way that a criminal defense attorney approaches, I guess, something like this with the courts?
Well, plea bargaining has always been, plea bargaining's been around for a long time. In Virginia Beach, we do a lot of plea bargaining with prosecutors on. Here's a classic. We've been talking about federal court. Let's move into the state court realm for just a minute. We have, and the desire to go in front of a jury anymore is just going away. There's very few trials anymore. And that's what our whole theme of our show today is that people plead guilty to crimes. 97% in the federal courts, 95% in the state courts. Now, why do people plead guilty in the federal courts? We've already talked about that. They've got the mandatory minimums. It's much better for them, unless they've got some kind of a slam dunk winner to go to trial. They're taking such a huge risk to go to trial. They're way better off going in and saying, okay, I'm going to beg. Go to the prosecutor. Try to charge bargain it down so I'm not looking at a mandatory minimum. Work out something where I can cooperate and give information so that I can knock my sentence down some more. And third, because of the Booker decision, recently, it's been within the last 7 years now, 8 years, the Supreme Court said that, wait a minute, judges can deviate downward from the guidelines. So it's kind of a three-part process now when you're trying to defend somebody in federal court. You charge bargain first with the prosecutor. You try to get the best possible deal on that. You then do some cooperation with them. If they're able to give information, that knocks them down some more. And then hopefully you go in front of a judge and you get the judge, you work down on the guidelines, and you also try to get the judge to deviate downward from the guidelines. Say your client's a special case and should be treated as someone below the guidelines. Most judges do stay within the guidelines anymore. Those guidelines, even though they're no longer mandatory, they are voluntary, but judges do tend to stay within them. Once again, we've talked about the Mcdonald case. Judge Spencer in Richmond deviated way down from the guidelines in that case. Although he still gave them some time. But if you've just joined us, we're Justice for All. I'm here with Greg Hall. He's my producer. And Dee is over here as our engineer. And we're talking about plea bargaining in the federal and state courts and why people come in and don't want to take a risk on a trial. Give you an example. Virginia is one of the very few states, and this is one of the interesting things when you're talking with a person about, okay, do you want to go to trial or not? And do you want to ask for a jury or not? Right? Classic. You got the right to a jury. Anytime somebody pleads guilty in either in federal court or state court, there's a long question and answer session between the judge and the defendant. And they would just ask you questions. Your name. What's your name? How old are you? Can you read and write? Have you? What kind of education level have you got? Have you been over the the indictment with your lawyer? Have you had enough time to talk to your lawyer about what your defenses are in this case? Do you know what they have to prove in order to prove you guilty? Do you know that you've got the right to a jury trial? Do you know that you've got the right to cross-examine your accusers? Do you know that you've got the right to defend yourself? Yes, yes, yes. Has anybody threatened you or forced you to plead guilty? No. Have you had a chance really to spend some time with your attorney to go over possible defenses? Yes, I have. Are you pleading guilty because you are in fact guilty of the crime? And you were, you were talking about this before, because your question is, you've been talking about this, what's called an Alford plea. And now sometimes when people come in, they will say, well, I'm going to plead guilty, but I'm really not guilty. And we can talk about that in just a minute. Most of the time when people come in and plead guilty, the judge has to ask them that question. Are you pleading guilty because you are in fact guilty? And the person will say yes. All right, well, because they are, and they've said they're guilty. That's always it's a tough question to get to with a lot of my clients. Yes, I'm guilty.
Wow. Well, I would
because
imagine
they've been telling you all this time that they haven't, and finally they get the plea agreement that they like. Okay, I'm guilty now.
Okay, so, or if they see the evidence, right? I mean, that the state has against them in that case.
Yeah, I mean, so by the time a person pleads guilty in state court, I mean, the lawyers had plenty of time to go over the evidence that is against them in the case. I know that it is a fact that when you're appointed to a federal case, and I do a lot of that kind of stuff, and you get appointed to a federal case, a lot of times you don't know anything about the case the day you're appointed, and you go see your client in the lockup, and you're doing a bond hearing or something, and you don't know anything about it. Meanwhile, the government has been working on this case for 3 years. I mean, wow. It's been part of an investigation or a grand jury, and it's like they have everything. They've got reams of information. They've interviewed 50 witnesses. They've got photographs. They've got recordings. They've got DVDs. They've got evidence coming out of the, everything, and you don't know anything. And so, and so you go see the client and you see the indictment, and then you're going to do a detention hearing. Perhaps you get him out on bond, maybe not. And then you're going to walk into court, and they're going to be saying, well, okay, your arraignment is next week. And you'll go into the arraignment, and you're going to plead not guilty and schedule the case for a trial maybe 2 months out. And on that day, a lot of times you'll sign a discovery order with the prosecutors, and they'll drop a big notebook on you and say, here's the case. And so you go, oh, okay, here's the evidence. And then you'll go see your client and go over what it is that you've got. So you got to get up to speed pretty fast, because in our area, you've got a trial date set within 60 to 90 days. Now, some of these more complicated cases, they'll set a trial date that's further out. But it's not necessarily, it's not an unreasonable period of time. You can have time to get ready for the case, but you got to drop a lot of other stuff to get ready for it.
I mean, 3 years of evidence. I mean, does the person that's been accused of the crime, do they even know how much information the federal government or state has on them?
No, a lot of times they won't, but then you'll just go over it with them, and then all of a sudden they'll find out that a lot of people have been talking and saying this and that. So, but that's the federal system. In the state, it's pretty much it's a little different when you're doing the state court cases. The federal system, they rarely ever indict people that they don't just about know they can convict. I mean, they're much more methodical. The federal system is much more methodical. They don't bring cases. A lot of times in a state court case, you'll have you'll have some woman come out and say, I was raped. And, it might not even be a very good case, but they have a duty right away they're not going to wait around for 3 years to review the evidence in the case. They're going to go out and arrest the guy that night, and he's going to be in jail, and he's going to be telling you, I didn't do it. She's making it up or whatever. And it might well be that she's making it up. It might be that case gets dismissed at the preliminary hearing because she's not a very good witness. But so the state court cases have a tendency to, and that doesn't necessarily have to be rape. Let's take something that's maybe less sexy. Let's say it could even be something like a grand larceny case where some roommate has said, my roommate stole my laptop. Boom. They charge you with grand larceny. And then it turns out that there was a good defense, and you get to court and it gets broken down to some kind of misdemeanor, goes away at preliminary hearing. So there's a lot more cases that get charged and end up with something other than a conviction or something much less than what's charged in state court than in federal court. We're about to go to a break in just a minute, but when we come back, what I wanted to talk about was the tough decision that we have to make sometimes if you do want to go to trial in the state court system, whether or not you want to ask for a judge or a jury. Because in Virginia, the juries do sentencing. And we're really unusual in that sense, is that we do the sentence. A jury will actually do the sentence, and judges will generally not disturb what the jury recommends in a case. And since we have sentencing guidelines in Virginia and the juries don't get to know about it, that changes a lot of the way things work. For instance, let's say you're charged with a drug offense. And I'll say you. None of us are, of course. But let's just say somebody's charged with selling a drug. The mandatory minimum on that is 5 years if the jury hears the case, because the jury doesn't know that anybody can give probation or anything like that.
So they're not educated on the sentencing process at all?
Lawyers try to during the course of closing argument to tell them, but if you try doing that, and I'll tell you, we have what's called a bifurcated system, where a jury first hears whether or not the person is guilty or not. They have no idea what the sentence is. And so they might decide that somebody's guilty, and then, and only then, in a second proceeding, they find out what they have to give that person as far as a sentence. And that's when they find out, oh gosh, you mean the sentence in this case is 5 years, minimum to 40 years maximum. So we're going to take a break. This is Justice for All. I'm here with Greg Hall and Dee, and we'll be back in a few minutes, and we're going to talk about guilty pleas in the state system.
If finances are holding you back from enrolling your kids or grandkids in private Christian schools, call the radio station at 488-1010. We have a partnership program with several schools on the peninsula and the south side that allows us to offer a 35% discount off tuition for preschool through the 12th grade. Give us a call today at 488-1010 or visit our website at tuitionsolution.org. Did we mention we added daycares to the site? tuitionsolution.org.
Hi, this is Greg Bigaveras. Join me for Sports Scene each Wednesday from noon to 1 right here on News Talk 1650 WHKT. You can also hear the show on TuneIn as well. We will talk to local, regional, and nationally acclaimed sports guests, and we'll interact with our audience as well at Greg Bick on Twitter. Sports Scene, Wednesdays from noon to 1 right here on 1650 AM.
RM Designs T-shirt printing and more is located in Smithfield, but serves all of Hampton Roads. They specialize in vinyl design shirts, apparel, window stickers, cups, and other specialty gifts. They also have rhinestone and embroidery designed apparel, and they offer Pandora-style beads and hardware to create a one-of-a-kind piece of jewelry. RM Designs T-shirt printing and more caters to businesses, sports teams, churches, groups, and family reunions. They also offer a great fundraising package should you be in need of money for a special project. And they also do home parties if you and your friends would like to get together and make your own creations. RM Designs T-shirt printing and more can be reached at 757-255-9140. That's 757-255-9140. Email them at rmdesigns11@aol.com or find them on Facebook at RM Twisted Designs. You can also place orders directly off their store at storeenvy.com/RM Twisted Designs.
All right, we're back at Justice for All. I'm George Yates, and I'm here with Greg Hall and Dee, and we're talking about trying a case in state court, and the decision to plead guilty or not guilty, and the decision to take a trial in front of a judge or a jury. And a lot of people, of course, would love to have, and this is what a lot of these articles that we've been reading about, the fact that the jury trial is the foundation of our Constitution. It's the foundation. It's what the founding fathers envisioned, that we would have a jury of our peers to decide our guilt or our innocence. And And so it's the cornerstone of our entire system. And it still works, and we still have plenty of jury trials. I'm not saying we don't have them, and they're going on all the time. The question is, do you want one on this particular case? And here's the dilemma that you've got. Now, for instance, let's say you're trying a DUI case. Something simple, like a DUI, where the mandatory maximum penalty is 12 months. In a state like Massachusetts or California even, and we've had guests on our show that try cases in Massachusetts and in California, they'll have a week-long jury trial for a DUI. And the reason they do that is because there's a good chance that if they try that case in front of a jury, they might get acquitted. And if they don't get acquitted, it doesn't really matter because the judge is still going to do the sentencing. And so they might still get probation and a restricted driver's license or whatever you get under the laws of those states. Now, in Virginia, not too many people take jury trials on a DUI. Why? Because on a first offense DUI, most people do not go to jail. On a first offense, you get probation, you get a restricted driver's license, you got to go to some alcohol counseling and so on. But for the most part, the general sentence on a first offense is all probation. We'll try that case in front of a jury. The jury doesn't know. The jury, if they find you guilty of the DUI, will then get a range. And they'll say, okay, well, you can give this person up to 12 months in jail. You don't have to give them 0 time. You can give them a fine. You can give them a day. You can give them a week. You can give them a year. And there's no sentencing guideline. So how many people are going to do that? Are you going to take a chance? If you try the case in front of a judge, you might be found guilty, but at least you know you're probably not going to go to jail. So what are you going to probably do? You say, okay, here's your choice. You can go in front of a jury, but if the jury convicts you, they could give you 3 months. If you get somebody on that jury. Let's take another type of offense. Let's say you're charged with, like we were talking earlier about a drug offense, and this is a classic one that goes on almost every single day in the courts in Virginia Beach. We have a Commonwealth Attorney's Office that has had a policy for over 20 years now that says we do not do bargains with drug dealers. That's it. So if you get caught selling cocaine or heroin or LSD or any Schedule I drug, you can plead guilty, straight up, no deal, and get sentenced by a judge. Or you can take a trial, but we're going to request a jury. Commonwealth can request a jury in Virginia. The defendant has the right to request a jury, so does the government. And they routinely will do that. Why? Well, because the legislature has said that a person that sells drugs has got the range is 5 to 40 years. 5 minimum, 40 maximum. A judge, if he's sentencing you, can suspend time. A judge might say, and in fact, the sentencing guidelines for somebody that's a first offender that's selling drugs, he's probably going to give sentencing guidelines of somewhere between around 7 months to 1 year, 4 months, something like that. So you plead guilty to selling drugs in front of a judge, you'll probably do about 12 months on a first offense. You'll get 5 years suspended, 5 years minimum. The judge has to give you the 5 years because that's the minimum sentence that the legislature has set. But he doesn't have to make you serve it. He can say 5 years, I'll suspend all, but 12 months, go to jail. Okay, that same defendant says, I am not guilty. I want to go to trial. Commonwealth says, fine, we'll go to trial, and we're going to request a jury. Now, if the jury finds you guilty, the jury's not going to know what the sentence is until after they find you guilty. They're going to come back, and they're only going to have this one choice. Okay, you may sentence him somewhere between 5 and 40. Go back into chambers, jury room, deliberation room, and come back and tell us what your sentence is. They could come back and give you 30 years, and they do. And how many people you think request jury trials anymore, or how many drug dealers go to trial anymore with that kind of choice?
So
zero.
The jury has no knowledge that could the jury suspend part of the sentence if they knew about it? So they can't even they don't even have that authorization or that opportunity.
No, and lawyers don't have the right to get up in front of them and say, "Oh, ladies and gentlemen, let me show you what the sentencing guidelines would be had this defendant just been found guilty by this judge. You'd be looking at 12 months." And even then, the jury would have to give them 5. Now, that's not to say that you can't exercise your right to a trial. The jury comes back and gives you, let's say, the mandatory minimum, the 5, and the judge is actually going to be the one doing the sentencing. I mean, technically, the jury's recommendation is a recommendation. The judge does the sentence. Technically, the judge has the right to say, I'm going to suspend some of that time. He could do that. They do not do that ordinarily as a rule. If the jury comes back and says 20 years, the judge is probably going to say, okay, 20 years. It's rare that they will suspend a jury sentence anymore. If that's the jury's verdict, that's what you get. So we've talked about, the theme of our show today was how many people come in and plead guilty to crimes that they didn't commit. Well, if you've got somebody that is charged with that sort of offense and you're their lawyer and you're saying, well, if you want to plead not guilty to this offense, you're going to get a jury trial. And if you're convicted, you're going to be pulling at least 5, and you could get 20 or even as high as 40. What do you want to do?
Now, see, that's where, okay, and that's where when I started reading these articles and we were talking about this, why innocent people plead guilty or whatever, as an outsider on the criminal justice system or, haven't gone through stuff like that, and a lot of people haven't, their opinion, I think, would be like mine. If you're innocent, you shouldn't plead guilty to a crime you didn't commit and let the system itself with a jury, all that evidence come forth and you will be exonerated. But clearly, in your experience, that's not the case, right? Or is that how?
Well, I'm always impressed with, because a lot of times you don't know. A lot of times you got certain cases and you get an offer that say it's just too good to be true, and you take it to your client, and the guy says, "Oh, I'm not taking it. I'm sorry. I didn't do it. I'm not taking it. I'm going to trial." And you go, wow, he really is innocent. Okay. In fact, we've got an article about this fellow that did all that time. It's a great article by a King County, that's Seattle, it's King County, Washington. And it was a prosecutor there. There was a fellow that had gotten found guilty of some kind of a home invasion, pistol whipping thing or whatever. He did 10 years on a charge. And it was an Innocence Project type case. And the prosecutors got involved in it, and they were trying to determine, and they didn't have DNA. There was no way to really know that the guy was innocent or not, but there was just something about it that bothered the prosecutors. And they actually went down and they started interviewing the defendant himself to ask him about the fact. This was years after he'd been convicted, had done like 10 years on the offense. And they offered him a deal to plead guilty to some lesser charge and get credit for like time served and get out, and he refused to do it. Even then. And that's when the prosecutor, and it's a good article by this prosecutor that said, wow, and you'll get, there's people that, no, they're innocent. And listen, it's been easy for me for many years. I'll say, look, you know whether you did this crime or not. A lot of times prosecutors make you an offer. You say, here's the offer. If you did it, this is a great offer. If you didn't do it, then it's not a good offer. It's your call. It's your decision. And because the tendency to go to just, and a lot of times now, if you don't have any kind of an offer, sometimes some of the most difficult decisions you got in a case is when you've got an offer that's good on the table, because you've got a guy that's been saying he didn't do it, he didn't do it, he didn't do it. Now you've got this offer that's almost too good to be true, or he's not doing any time. It's all probation, something like that. You take it to him. And now he's got a choice to make. And, there are people that would say, you mean I can go to trial and if someone believes the victim who I say is lying, but if they believe that person, then I could be getting life. But here's an offer on the table to plead guilty to a misdemeanor and do no time. So there you go.
Yeah, that's a heck of a dilemma. And like the guy that did 10 years, that's a very principled man to.
And I've had that happen. And I've had that happen where someone will come in and they've offered, it's a classic. Let's say it's a shoplifting case or something, and the guy says, I didn't do it. I didn't, this is not. and it's maybe a grand larceny. So it starts out as a grand larceny. It didn't do it. And then they offer a misdemeanor, petty larceny. Oh, okay, I'll plead to that. You go, all right, well. But then there's another, so yeah, you were guilty. You just were saying you weren't, right? But then there's another person that might come in and say, no, I'm not completely guilty to a misdemeanor any more than I didn't do it. It doesn't matter whether the crime is dropped all the way down to littering. I didn't commit the offense, so I'm not going to plead guilty to anything I didn't do. There are people that are principled like that, and you say fine. And the fact is that many times they prevail at trial because they are that kind of credibility and that kind of perseverance comes through in court, and you can win the case because a person says they didn't do it, and you respect that. You don't go, and it's the most difficult thing. And we've talked. One of our segments today that we're going to talk about is this whole thing about plea agreements. Because there have been some Supreme Court decisions that we've talked about that get on defense lawyers about communicating plea agreements to their clients. And Jed Rakoff, who's this federal judge up in New York, who's a well-respected federal judge and was the subject of another guest that we had. Joel Cohen wrote a book about blindfolds off, and Jed Rakoff's a good friend of his, and Joel Cohen was a guest on our show. And Jed Rakoff has written several articles about this and has proposed that judges actually get involved in the plea bargaining process. In Virginia, by law, a judge may not get involved in any plea negotiation process at all. When you enter into a written plea agreement in a state court in Virginia, it's a paragraph in that plea agreement that says no judge of this court has participated at all in this plea agreement. So by law, judges may not participate in plea agreements.
What's the logic behind that?
Well, apparently, according to Judge Rakoff, there's not a lot of logic. Judge Rakoff would like to change that because he thinks that, well, the reason, I guess, is so that they wouldn't feel like a judge is pressuring one side or the other to do something, because perhaps there is a perception that there might be a judge that's maybe ramming the case down the defendant's throat or something, or letting the defendant know, I'm going to find you guilty, so you should plead. I don't know. It's a good question. Maybe we should make that a subject for another show. But the rule has been that judges cannot participate in any plea negotiations. Sometimes they will, kind of informally. Okay, what's this case all about? Kind of, talk about it a little bit. I've had judges, for instance, call you up to the bench right in the middle of a trial and say, have you all talked about a plea agreement in this case? You know, like, I've got a problem. I don't want to find the defendant necessarily guilty of what he's charged with, but maybe I can find some way to work out a middle ground. And that's when lawyers kind of go back and start to confer. And even though the judge hasn't technically involved himself in a plea negotiation, he's let the lawyers know that he'd like you to maybe kind of work this case out so he can come to some middle ground on it. I think judges will do that and not run afoul of the rules, and let the lawyers know that there ought to be a middle ground, that maybe this case shouldn't be going to trial right now, and let's try to find middle ground. It doesn't happen very often, but that has happened to me in the past.
Would there be maybe some common mistakes during that plea bargaining process or explanation of it that like an inexperienced attorney might make? I mean,
Well, the thing that's got this whole thing started is there's several cases where apparently there were some plea agreements or plea offers that had been made that had not been communicated to the client. Perhaps had just been rejected outright by the defense lawyer, not communicated to the client. You've got a duty, just like in any case. I mean, if I'm doing a personal injury case and I've requested $1 million and the defendant comes back and says, well, we're offering $20,000. Okay, I'm asking $1 million, and they want okay, we're offering $20,000. Now you kind of go, well, wait a minute, no, I don't think we. But you've still got a duty to call your client up and go, well, they've offered $20,000. Do you want it? Well, no. Okay, so no matter what the offer is, you've got to go communicate it to your client. And there was some Supreme Court decisions that you and I have discussed this week where the defendants were given new trials. and one which was very troubling to even some of the judges that dissented. There was Scalia and Thomas, and some of the judges were just horrified that somebody actually rejected a plea agreement on his attorney's advice. The attorney said, I don't think you should take this deal. And so the guy goes, okay. Then he goes to trial and he gets hammered. And then afterwards he goes, my lawyer really rammed this plea agreement. Didn't properly he didn't properly advise me on whether I should have taken this plea agreement or not. And so the Supreme Court said, well, then you didn't have effective assistance of counsel. We're going to let you now go back and maybe have that plea agreement entered against you. And so what that's done is there's several cases that have been on this whole plea agreement thing that now when you go in front of federal court or state court, judges routinely now are asking those questions. They'll say, have there been any plea offers made in this case? And that didn't used to happen 5 years ago. And now it's happening in almost every case. And the judges have a duty to do that now. Say, okay, have there been any plea offers made in this case? Yes. Okay. And that judge doesn't necessarily have to know what they are, but he's got it that, and then he'll ask the defendant, was that communicated to you? This is if somebody's, let's say, pleading not guilty and they're about to go to trial. Have there been plea offers made? So you need to know that. And that's now a standard part of the colloquy that a judge now has with a defendant in a criminal case. If you just joined us, this is Justice for All. I'm George Yates, and I'm here with Dee and Greg Hall. And we're talking about federal court and state court practice, guilty pleas, trials, jury trials, all that sort of stuff. Kind of stuff that a lot of people don't really know about unless they've been charged with a crime. And so since most of you out there have not been, you might not know some of these details. But it's always one of those tough decisions that you're going to make. The biggest and toughest decision that you're going to make in state court is, are you going to ask for a jury trial? If you try the case in front of a judge, it's not going to make much difference, right? I mean, let's say you plead not guilty and take a bench trial. Well, you're meaning a trial by a judge. If the judge finds you guilty, then he will sentence you, and you will get the benefit of going and getting a pre-sentence report and getting a set of what they call sentencing guidelines. Now, not every crime that's committed in Virginia has a sentencing guidelines, but a lot of them do. And so there's a range of sentence for each particular type of crime, and the sentencing guidelines are based upon what similar defendants have gotten in those types of crimes across the state. There's a clearinghouse, if you will, where every decision made by every judge in this state goes to a central bank, and they will basically lay out, the type of crime it is, the defendant himself, his criminal record, what other types of offenses were part of that crime, and you end up with a little sheet, and it starts out with the crime, and it's a score, it's a number score, and depending upon the type of crime and whether a firearm was used, let's say, whether there's other crimes involved with it, whether or not the person already has any other kind of criminal record in the past, whether they've gone to jail in the past, whether they have a juvenile record, whether they were on bond or probation at the time of the crime, all those things add up. If you've got somebody that's committed a crime, they committed some other crimes, and there was a gun involved, and the victim was really injured, and they have a prior juvenile record, and they've gone to jail before, all of a sudden their score can add up, and you can end up with a pretty high score. On the other hand, if it's a property type crime and your client's got no record, no juvenile record, no weapons used, well, then now you're talking about a less serious type of offense. And so you have the first thing you do if you're a criminal defense lawyer and someone comes into your office and they're charged with a particular crime, one of the very first things you do is you pull out your sentencing guidelines book and say, okay, worst case scenario, you're found guilty of this, here are the guidelines. This is what you're looking at. And so that kind of gives you a benchmark to start from. It might well be, you don't want to show it to them. You don't want to scare them too bad. It depends on the type of offense it is. because sometimes the guidelines can start out pretty daggone high depending upon the type of crime it is. But for the most part, for a lot of crimes, it's like where people think that they're really looking at some serious. There might well be that they're not looking at as serious of a penalty as they thought they might have. So, you know, your question earlier this week was how many people come in and plead guilty to something that they didn't do, and you know that happens, and that's what they call an Alford plea, right? And have you heard about the Alford plea?
I happened to come across it when I was reading some of those articles, but I don't know much about it.
Well, an Alford plea is when somebody. It used to be that there was a case. It was 1970. It was the name of the case was Alford versus North Carolina. And what happened in that case was the defendant came out. I think he was charged with murder, and they'd offered him manslaughter or something. They'd offered him a lesser crime. And he denied ever doing the crime. But they'd offered him manslaughter or something less than what his original crime was. Maybe it was second-degree murder. I don't have the file in front of me. But in Alford, the client came out and said, okay, I'm pleading guilty, but I didn't do it. And the judge wouldn't let him do it. The judge said, well, no, you can't plead guilty to a crime that you didn't commit. And so, that case went up to the Supreme Court. The Supreme Court ruled that judge, made a mistake, or if you will, they created a whole new rule of law, which says that yes, a client can come into court and plead guilty and still deny guilt. And in fact, so if you do that now, if I walk into court with someone that wants to take an Alford plea, and some prosecutors won't let you do it. Some prosecutors will say, well, no.
The deal goes away if they do that.
That's right. Mm-hmm. I want him to come in and say he did it. Otherwise, no, we'll go to trial. And you go, uh-oh. So, okay, now he's got to say, okay, I did it. I mean, so you find a lot of times prosecutors don't care. They'll go, all right, I'll let him take an Alford. It's all right with me. But the Alford plea says, I'm pleading guilty. I'm taking responsibility, but I didn't do it. And the judge will then go into a whole nother colloquy with the client. Okay, you're pleading guilty then because you think it's in your best interest to do so. Yes, I think it's in my best interest because if I don't plead guilty and I go to trial, we might have been scheduled for a jury trial that day. Now, if I get sentenced by a jury might give me a mandatory minimum of the 5 years that we talked about earlier, depending on the crime. But I know that if I take this Alford plea and there's a plea agreement that calls for me to do no time, probation, or something to that effect, or some much less sentence. So and it's what they call it. No defense lawyers don't like Alford pleas either, because if you're a defense lawyer, you're going in there and you're telling the judge that we're pleading guilty to something, but the guy's saying you didn't do it, and there's something kind of
feels wrong about that.
It does. Yeah, well, listen, if you didn't do it, then you should be taking a trial. You should be saying you didn't do it and go into trial. So it's one of those things that a lot of lawyers don't like to do. But it's the client's right, and if the prosecutor has offered you a deal and you've offered the deal to your client, the client wants to take it, and the client says, I want to take this kind of Alford-type plea after you've explained to them what they have to do, and the prosecutor says it's okay, well, then you're stuck. I mean, that's the client's right to do that. So that's how you end up with these Alford pleas sometimes. I mean, the lawyer would much rather the client say, I did it, because it just makes it okay, you're pleading guilty because you in fact did it, and so you're doing the right thing,
So without mandatory minimums, do you think there'd be a lot more jury trials? Or
well, the problem, you mean you're talking in state court?
Well,
no, because it wouldn't make any difference. It's not necessarily the mandatory minimum. I mean, I've only just talked about the mandatory minimum. Forget that for just a minute. Let's say you've got somebody that's charged with a sex crime, okay? They're charged with touching a child. Serious offense, right? I mean, serious, bad news. And the guidelines call for 3 years for the guy to pull. And he's saying, I didn't do it. Okay, but the prosecutor's offered you a plea agreement, and he's going to do this crime, and he's going to plead guilty to it, and he's going to get 3 years. Okay, and now, but if you don't take the deal, you're going to take a jury trial. And he's looking at let's say 3 offenses that carry 20 years on each. What do you think that jury's going to give him?
20 years.
On each. He could get 60. So what do you think he's going to do? Now, obviously he's got the right to a trial, and if he didn't do it, he should take a trial, and he should plead not guilty and go through the motions. But the point is, his risk, forget the mandatory minimum for just a minute, the sentencing range for that jury on these crimes is immense.
So in your world, I mean, it's all about kind of managing the risk, managing the upside. Well, here's a classic. One of the most classic cases that I was ever involved in was a capital murder case up on the Eastern Shore. I was involved in about 15 years ago. And here was a kid. He was the getaway car driver. These guys had gone in, and it was a terrible crime. 4 guys in a car. 3 of them jump out of the car to go in, and they were going to rob this house. The guy was not home. They thought they were just going to go in there and steal his money. They thought he had some drugs and, Rolex watches and all whatever kind of stuff, So they jump out of the car. One of them has a gun. The guy driving the car sits in the car. They go in. Terrible crime. There is a person in the house. One of the guys actually shoots the person that's in the house and kills her. Bad news. That was my client. I had the shooter. Okay? The guy in the car, they all come running out, and they jump in the car and they leave. Well, a week later, the guy that was the driver of the car gets caught. And because apparently the guy that did the shooting throws away the gun, but they steal a gun from the house and leave it in the getaway. And the getaway driver was so stupid that he leaves this gun in his car. And he saws off the serial numbers or something, thinking that can disguise the gun. Okay? Well, word gets around the town. This is up on the Eastern Shore, small community, as to who did this heinous crime. And the police are led to this fellow's car. And they go into the car. They find the gun. And the guy who came home and found his girlfriend dead, killed, identifies this as his gun. And it's found in this dude's car. All right? So, this dude was the getaway driver. He writes down a statement that says, I was just driving in the car. I drove up there. I didn't know that they were going to kill anybody. I didn't know anything about it. I just knew they were going to go in there and steal some stuff. I just knew they were going to, get some drugs and some money and whatever they could get. Well, when we come back from the CBS News, I'm going to tell you what happened in this case, because they offered him a plea agreement. They offered the getaway driver a plea agreement to come into court to testify against the other guys, and he turned it down. And we'll see what happens when sometimes people are offered plea agreements and turn them down and then decide to go to trial, because sometimes it is not pretty. This is Justice for All. We're about to go to a CBS News break, and we're going to come right back in just a few minutes, so stay with us.
Hotels after they abandoned their cars on Interstate 65. And girl died today. The 18-year-old is charged with first-degree murder. There is no word on the nature of the altercation. This is CBS News.
Times are different than they were when Geico started saving people money over 75 years ago. Everybody takes photos of their food nowadays. You can bet none of us kids would snap pictures of Mom's tuna casserole surprise. To this day, we don't know what the surprise was, nor do we want to. We didn't always have tasty food, but we always had great car insurance with Geico.
Geico, saving people money on car insurance for over 75 years.
I don't like sit-down dinners, I don't go to sit-down strikes. I like standing room only, and I don't ride bikes.
This pretty bad song is by a guy with pretty bad hemorrhoids. He needs Preparation H relief with the power of 2. First, use fast-acting Preparation H medicated wipes, then longer-lasting Preparation H maximum strength cream.
Let's sit together on the porch swing.
Preparation H. Don't stand for hemorrhoids. Use as directed.
And try specially formulated medicated wipes for women.
It's an annual college event in Detroit. WWJ reporter Jason Scott says it's all about getting kids to continue on with their studies.
Started 18 years ago, the annual college fair at Second Ebenezer Church offers city high schoolers an array of universities to meet with. Some previous attendees have returned.
We have students at Michigan State on scholarships. We have students at Howard and Hampton and some other historically black universities.
Youth pastor Elder James Johnson.
We're giving away scholarships, tablets. We have Samsung tablets that we're giving away and different gift cards just to encourage people.
Many of those scholarships are worth $2,000. Jason Scott, CBS News, Detroit.
Bao Bao is growing up. Officials at the National Zoo in Washington say the 18-month-old giant panda cub began the weaning process on her own a few months ago. Now that she's stopped nursing and moved on to eating bamboo and solid foods, she'll begin living separately from her mom. Deborah Rodriguez, CBS News.
Wearing glasses with Crizal no-glare lenses can make a big difference in your vision because neither scratching desert sands nor the waves of a raging river can keep your lenses from giving you the clearest vision possible. For superior water, dust, scratch, and smudge resistance, choose Crizal. Plus, Crizal gives you 25 times more UV protection than not wearing glasses. Crizal, live life in the clear. Ask for them at your eye care professional or learn more at Crizal.com.
What fuels you? Here's Paul, going to the ski slopes with his buddies.
Dude, double black diamond? Last one down buys lunch!
Paul fuels up at Exxon and Mobil stations, where our quality gasoline helps improve fuel economy. And now he could win $1,000 in Exxon Mobil gift cards just by telling us what fuels him, like skiing with his pals. 10 weekly winners. Full details at Exxon.com or Mobil.com. Exxon and Mobil. Energy lives here.
No purchase necessary. Ends April 7th, 2015. Restrictions apply. Actual fuel economy benefits may vary.
Okay, we're back. David Lindley, talked to the lawyer. Well, let's see. So those of you that stayed with us, what happened in that case? Well, this was the one that we talked about. It. There was a capital murder case that was on the Eastern Shore, and it was a terrible crime. Three fellows go into the house. They think there's not going to be anybody in the house. It's dark, and they think the guy that lives there is a dope dealer. You see a lot of this. You know, these idiots. They go in thinking they're going to, rob a dope dealer. They think that because they're a dope dealer, they're not going to call the police or anything else. Of course, they call the police all the time. And there are so many people that get arrested for these home invasions and go to prison forever because they break into dope dealers' houses and pistol whip them and do all these terrible crimes. And what do you think juries do to them? Imagine. You go into a jury trial, an abduction, a home invasion kind of case. Juries just give you 50 years. And that's, in fact, what happened in this case. They offered this 20-year-old getaway driver who worked at Purdue up on the shore. They offered him 10 years. You're going to do 10 years. And what happened is, and we have a law in Virginia called felony murder. If you involve yourself in a felony murder, if you involve yourself in a crime, a felony, and somebody gets killed during the course of that crime, you're guilty of murder. So you agree to commit a felony like a burglary at night, which is a felony, and then you go in and somebody gets killed, every single person, including the getaway driver, is guilty of murder. If you can prove that when the person went in and the getaway driver knew he was about to go commit a burglary, that's a felony. There's a murder that took place, or a killing even. It's felony murder. So this fella that was sitting in the car that had no idea that someone was going to be killed is now the getaway driver. The three guys come out after they've shot somebody. They all jump in the car, they drive away. The three guys dash off to Boston or wherever they were from. And the getaway driver, who's the only one who lived locally, is working at his Purdue job. And they find this gun, He confesses that, yeah, I was the getaway driver. They said, well, then you're guilty of murder. Because did you know they were going to commit a burglary? Yes. Well, then you're guilty of murder. He had a good lawyer. I won't name his name. But he had a good lawyer that said, take this deal. It's the best deal you're going to get. 10 years. 10 years, he's thinking. He's 20 years old. So he doesn't take the deal. But he'd already confessed. He had a written confession. Took a jury trial. 65 years.
65?
Mm-hmm. 65 years.
Wow.
Well, because the jury heard that he'd been the getaway driver, that they'd heard the whole story, and that he had pulled up in front of this house, and these three guys got out, and he knew that one of them had a gun, and he knew that when they came back that they'd shot somebody, and he knew when they drove them away that he was basically participating in this felony in which a young lady, mother of two, was killed. Jury gave him 65 years. And he had turned down a 10-year guilty plea bargain to come in and testify against the co-defendants in that case and take the best deal that he could. That was the best deal that he was going to get.
If he'd have taken the 10, would he have been out sooner on good behavior or no?
Well, in Virginia, this was still after, there's no parole in Virginia, so you do 85% of your time. So he'd have done 8.5 years. He'd certainly be out by now. He's still in prison.
Wow.
Yeah, this all was like in 1999, 2000. I remember this case was around 2000. So he's still there and will be there. And his probation officer hasn't even been born yet, to say the truth of the case. So the other two co-defendants, there was three co-defendants. The other two co-defendants were given 15-year offers to plead and testify against the shooter, who was my client. And of course, my client denied any offense, denied it at all, and never made any statements or anything else. And the sad thing about the whole thing is that they were still unable to convict my client of murder. Convicted him, I think, of robbery, and he got 23 years, I think, total. The other two guys got 15, and the guy that got the most time in the case was the guy that didn't take the plea agreement. It was the getaway driver. He got 65, and he was the least culpable of the four. So, it's just when you've got, and he had a really good lawyer too, but he just wouldn't listen and wouldn't take his lawyer's advice. So, and ultimately that's what ends up happening when you come in and you've got a criminal case and you've got a client that it's hard because you have to tell your client, here's your options. Here's the plea agreement, and what do you do? And it's ultimately the client's decision. I mean, when they get up there in front of that judge, it's like, have you discussed with your attorney what the offer is and what you're pleading, whether you go to trial, not go to trial, and so on and so forth. But ultimately the decision is, have you decided for yourself that you want to plead guilty? That's the question. Have you decided, after this discussion that you've had with your lawyer, have you decided for yourself that you want to plead guilty? Yes. So it's your decision. And as much as you'd like to say that, and of course the lawyer is going to have to say, I think it's your best option. I just met with a client in the jail not that long ago, today, as a matter of fact. And, it was I'm telling him, I think that under the circumstances of this case, this is a pretty good plea offer that has been made in your case. And I think that you should take it. So I think that lawyers do that. And they, in fact, will tell you, the client, what, in fact, their opinion is on it. But ultimately, it's the client's decision to do it. We are Justice for All. It's a beautiful day out there. It actually warmed up to, 44 degrees when I pulled into the studio today. I couldn't believe it. It's actually not freezing. When was the last time we had not freezing weather here in this area? It's been a week?
I don't know. I know you still needed a 4-wheel drive to get into the studio.
We sure did. And, I think that it's probably going to not melt enough in order, and then when it gets cold again, it's going to be even worse.
Might even ice over. But, yeah, the roads certainly main roads are now free. And, I think we're almost back to normal. Although there's still a lot of winter wonderland, and I was just saying how, mild of a winter it's been before this. But quick question, George. So because I'm fascinated by this process. So do you see with all these judges, it looks like they're kind of coming out against certain things. Do you see the status quo with plea bargaining as it is today, moving forward in the future, or do you think there's going to be some reforms?
Oh, no, I think it's here to stay, and it's going to keep going this way. I think that we've got so many a lot of it does. I think that the question is going to really come down to, prosecutors and their charging decisions. And so often that's what you have to depend upon. Some classic examples. And as the literature is making clear, since the prosecutors have the power in the case, the way it is in the federal court now, it's the prosecutors that have the power. The judges have some power because they can deviate downward from the guidelines. But the real power is still vested in the United States Attorney's offices because they can decide to not charge the offense. They can decide to break the charge down from where the mandatory minimum is. They don't have to charge the mandatory minimum crime. The mandatory minimum doesn't kick in until you have a certain amount under drug cases. So the prosecutors can decide or not decide. And so that's where all the power is in the prosecutor's offices. In state court, our sentencing guidelines are a little bit more flexible for state court judges than they are for federal court judges. So there's more power for state court judges than there is for federal court judges in general in the sentencing process. So a lot of times a prosecutor might say, we'll give you, I'll do a plea agreement of 3 years or something like that. You might say, is that the best you can do? Well, then I will, I'd rather plead without a plea agreement. Maybe a judge will give me less. So a lot of times a prosecutor might say, I'll tell you what we'll do. Let's do a 3-year cap where the worst you can get is 3 years, but a judge can give you less. So that's a plea agreement that sometimes you'll come up with. Say, okay, we're going to agree to plead guilty. We're going to ask for a pre-sentence report. We'll do the sentencing guidelines. We'll come back. We'll have a sentencing hearing. And the judge can sentence up to 3 years, no more. And then you've got that kind of option that you've limited your downside with the 3-year cap, but a judge could give you 2 years or 18 months or something like that. So that works out, and a lot of lawyers and prosecutors will work those kinds of decisions out that way.
Do you ever find that you have to maybe call a prosecutor out on, maybe they're a little too aggressive and want to sentence more, and you have to say, hey, stand up for the client? Or do you have, how does that process work where you feel like, hey, this isn't the best deal that I can get?
Well, no, it's very cordial. It's a very professional relationship that lawyers and prosecutors have. We're dealing with each other all the time, day in and day out. You don't burn your bridges. You're working with this same office over and over and over. So
they get to know you, and you get to know kind of.
Well, that's just the way it is, and there's nothing. Hopefully, there's nothing personal about it. Mm-hmm. There's certain kinds of law practice that I think get real personal. I think sometimes divorce lawyers, and sometimes it gets real. So I've heard a lot of civil. There's sometimes complaints amongst the lawyers in civil cases that there's a lot of lack of civility. Sometimes, but I think amongst the criminal bar and the prosecutors and the defense lawyers, it's a very cordial, very personal type thing. Everybody's just trying to do their job, what they think is the right thing. Sometimes it gets a little personal, but rarely. I think you want to try to stay away from that because you're not doing your client any good by getting, upset with a prosecutor or anybody in the case. And there's no reason to do that. The prosecutor's got their own opinion about it, and sometimes they're very you might have a certain prosecutor that gets really emotional about a certain kind of case and kind of wants to take it out on you. And you got to wait a minute, I didn't do the crime. Don't get mad at me. I didn't do it. Okay, fine. Because, everybody's got their own personal approach to things. But in general, no, you don't call anybody out. You might say, I think that's too much. Please, can't we work something out of this a little bit? And you've always got the right to say, well, no, you've got the right to a trial, try the case, or ask for a jury, see if they'll give you less, or plead just straight up, plead with no plea agreement. When I was a prosecutor, we didn't have sentencing guidelines when I first started out. So I didn't often know what a case was worth. So a lot of times I might say, you might want to come in and say, well, what kind of plea agreement can you offer me? You're a defense lawyer. And I would go, I don't know. I don't know enough about what a judge would give in this case because I haven't been doing it long enough. So how about this? If you want to plead not guilty, we can have a trial. Or if you want to plead guilty, then we can just go to a sentencing hearing and you can just argue it. But I don't know if I want to offer a plea agreement for a certain amount of years because I don't know what it's worth because I haven't done it enough and I'm not experienced enough right now. You can go down the hall and ask another more experienced lawyer as to what the right amount of time might be and try to work it out that way. But sometimes it was better just to say, why don't you just plead with no agreement and let a judge do the sentencing. And that's what a lot of lawyers do, by the way. There's a lot of cases where a lawyer will just plead the client guilty, or the client will plead guilty with no plea. He's pleading guilty with no plea agreement, just going and asking for a pre-sentence report and do the sentencing. Because guidelines allow you to have a pretty good idea, since most judges in the Virginia State Court sentence in accordance with the guidelines, and you already know what the guidelines are before you plead guilty. It's a pretty simple matter to say, well, this judge is probably going to sentence within the guidelines. He might not. He or she might go down. They rarely go over. So I'm safe by just pleading straight up, as they say, with no plea agreement, and let's just go do the sentencing that way. And that happens a lot, especially if you're asking for some kind of special disposition. A lot of times you might try. I mean, there's lawyers that'll still go out there and try to figure out a way to say, maybe you'll find him not guilty. We'll plead him guilty. Maybe you can defer a finding of guilt and find him guilty of some lesser offense, or after that still happens, where we're begging for something less than a felony, let's say. Prosecutor can't agree to it, but maybe the judge will do it. And prosecutor kind of stands mute. So there's all kinds of reasons why somebody might not want to have a plea agreement. Might just want to plead straight up and let the judge do something, and maybe you can get better than what a plea agreement might have been.
Right. Now, we kind of had gotten into it before, and one of the articles that I guess we were reading had talked about some of these mistakes that the inexperienced attorneys make, like even just the filing deadlines or...
Well, those weren't even inexperienced lawyers. They were experienced attorneys that made these. This was a horror show of this article about these lawyers that do a lot of this habeas corpus stuff on these death penalty cases. And this was back when the Clinton administration had cut that deal with the contract with America, that Newt Gingrich Congress, and they basically had this 1-year moratorium on these death penalty cases, and they only had 1 year to file those habeas corpus petitions, or else it was over. And these lawyers that did all this death penalty work, they missed the filing deadline by 1 day. All these lawyers that were and they were experienced lawyers. This one lawyer, she was so conscientious, and she read the habeas corpus stuff backwards and forwards, and she missed the deadline by 1 day. And the guy later was executed, and she went to his execution. This was just a horrendous case. You miss your filing deadline, it's done. It's over. There's no... and these lawyers would miss the deadlines because they mailed in their petition, and they mailed it in 3 days early, and the mail took 4. Instead of doing it overnight courier, or, come on. Now, you at least need to know that the mail might take a week.
Wow.
So those are some, real
Well,
horror
are there
stories.
filing deadlines for regular crimes and all that stuff, or is this just...
Ordinarily, no. Appellate work is the one with all these filing deadlines. And
Gotcha.
if you miss a filing deadline, you're out of luck. And that's what happens so often. When you do appellate work, the guidelines are very rigid. You have to file the transcript within a certain amount of time, file your notices when they're within a certain amount of time. And if you don't file it if you're 1 day late, you're out of court. That's it. Sorry, too late. No excuses. That's it. You're done. You're out of court. And so, that was some real horror stories about those clients that were denied their writs of habeas corpus because the lawyers missed the filing deadlines. If you just joined us, I'm George Yates, and this is Justice for All. We got a few more minutes to go in our show. How about this Boston? There's in Boston right now, they're still selecting this jury up there for the Boston Marathon massacre guy.
That's it's pretty crazy because they're having a real hard time finding.
It's still going on, right? That's what this article is all about. Notes from a Boston courtroom by Kevin Cullen.
Right.
Yeah, that's going to be interesting. The story in Boston right now is that they're selecting jurors, and it's a double-edged sword because the Boston jurors all know about the case. They've all formed opinions. Most of them, I think the vast majority of them, believe that Mr. Sarnev is guilty. What's his name? Is Zokhar Sarnev. How do you pronounce that? Dzhokhar.
I have no. You did a better job than I would.
Sarnev. In any event, in fact, but I don't think you could. And they've talked about moving that trial out of Boston. The judge O'Toole has refused the change of the defendant's change of venue. But the fact is that the defendant in this case is probably better off trying the case in Boston, from what I've been able to glean from this article. And that is because of all the states in the Union, Boston, or certainly Massachusetts, probably has the highest percentage of people that are opposed to the death penalty as opposed to other types of, you might go to some more liberal states. You might go to, maybe it's Oregon or, Washington or California maybe, but certainly you would not want to try this case in the South, where the death penalty, 80% of the people approve of the death penalty. I think a number of people, so that's what I'm getting from this article, is that the people know about the crime, and they have a tendency to want to find the guy guilty, but they're less likely to give him the death penalty in Massachusetts. It's a liberal state. They elected Mitt Romney, for God's sakes.
Well, I think that, for sure, it's that has been so publicized in the media. And, of course, didn't they catch that guy in the boat or something? Was that the guy that they found in the boat with the gun or with the,
Yeah, everybody knows he's guilty.
Yeah.
It's like, they try to draw a parallel between this and the Oklahoma City bombing, where the Oklahoma City killer, what was his name? Tim McVeigh, is that his name?
Mm-hmm.
Yeah. Timothy McVeigh. Everybody knew McVeigh was guilty too. And they moved his case out of Oklahoma City to Denver. And it didn't make any difference. He was convicted in Denver and given the death penalty, and he was executed. This fellow, whether or not he's probably better off staying in Massachusetts than going anywhere else. So that's a really interesting case. That they sort of, like I said, a double-edged sword, where they have a large concentration of jurors that already have opinions on whether he's guilty or not, but yet at the same time, where they're having a hard time finding death-qualified jurors. Trying to death qualify a juror, you guys, you've got to find that the person could impose the death penalty. It's something I've always had a problem with. If you've got the right to a jury, a random jury, a jury of your peers, and yet in death cases, the prosecution has got the right to demand that every single person on that jury could, in fact, impose the death penalty if the circumstances were right. And I've always kind of thought that in and of itself is kind of unconstitutional, because if you've got the right to an impartial jury, how do you have the right to pre-select whether or not that person could kill? Yeah, it seems like you gotta just take your chances, but that's not the way it is.
Or maybe it should be half and half, fair. But the guy that you interviewed, what was his name? That was a trial consultant that helped select juries.
We've had a couple of trial consultants, but Richard Gabriel?
Yeah. Now, he might even find it challenging to select a jury with this particular case, right?
They of course. Yeah, that's. I'm sure they've got trial consultants on both sides in this case. So we've got just a couple minutes before we're going to go to the break, but he's got 17 charges. Sarnev is facing 30 separate charges, 17 of which carry the possibility of the death penalty. A questionnaire filled out by 1,300 prospective jurors was supposed to speed up the process by weeding out those who are either clearly biased or vehemently opposed to the death penalty. Instead, the voir dire process has revealed a sizable number of jurors who are just not sure if they can be impartial, not sure whether they could in good conscience vote to impose the death penalty. So the prosecution was saying, we want to keep this charge right here in Boston because the Boston, they're upset, they're pissed off, they want to convict this guy, but I'm in Boston, and folks are liberal, and they are not inclined to vote for the death penalty. So it's going to be an interesting trial. And so maybe he doesn't get the death penalty, but he gets convicted and spends, 17 life terms. I mean, he's going to never get out of prison, of course. And the question is whether or not you're going to impose the death penalty on him. We're going to take a break here. This is Justice for All. I'm George Yates. We're here with Greg Hall and Dee, and we're going to be back for the last 30 minutes of the show. We still got a lot more to discuss, and we're going to talk about the Brian Banks case and Innocence Project, and what's the other guys you want to talk about? The Marshall Project.
Oh, yeah.
Yeah, they're pretty cool. All right, we'll be right back.
If finances are holding you back from enrolling your kids or grandkids in private Christian schools, call the radio station at 488-1010. We have a partnership program with several schools on the peninsula and the south side that allows us to offer a 35% discount off tuition for preschool through the 12th grade. Give us a call today at 488-1010 or visit our website at tuitionsolution.org. Did we mention we added daycares to the site? tuitionsolution.org.
RM Designs T-shirt printing and more is located in Smithfield, but serves all of Hampton Roads. They specialize in vinyl design shirts, apparel, window stickers, cups, and other specialty gifts. They also have rhinestone and embroidery designed apparel, and they offer Pandora-style beads and hardware to create a one-of-a-kind piece of jewelry. RM Designs T-shirt printing and more caters to businesses, sports teams, churches, groups, and family reunions. They also offer a great fundraising package should you be in need of money for a special project. And they also do home parties if you and your friends would like to get together and make your own creations. RM Designs T-shirt printing and more can be reached at 757-255-9140. That's 757-255-9140. Email them at rmdesigns11@aol.com or find them on Facebook at RM Twisted Designs. You can also place orders directly off their store at storenvy.com/RM Twisted Designs.
Hi, this is Greg Bigaveris. Join me for Sports Scene each Wednesday from noon to 1 right here on News Talk 1650 WHKT. You can also hear the show on TuneIn as well. We will talk to local, regional, and nationally acclaimed sports guests, and we'll interact with our audience as well at Greg Bick on Twitter. Sports Scene, Wednesdays from noon to 1 right here on 1650 AM.
Leaky faucet, refinishing old countertops? Hey, Gary Sullivan here. Perhaps you're restaining a deck or painting your living room. Whatever it is, let me help. I'm here to give you the tips you need to finish those pesky projects you've been putting off. If you're restaining, I have a tip for that. Can't get the paint off the hardwood floors? Got a tip for that too. I'm here to make sure that $5 repair doesn't turn into a $500 repair. Join me right here every weekend.
Saturdays at noon, Sundays at 9 a.m. on AM 1650 WHKT, The Answer.
All right, we're back with Justice for All. I'm George Yates. We're about to go slide right into our last 30 minutes before we're going to get on out of here and cruise back out there into that nice warm afternoon. What's the temperature out there now, boys? About 40, 45?
Yeah, 45.
Oh, man. Well, you know what? It's better than 15. Well, listen, Greg, you were really fascinated by this. What is an emoji anyway? I don't use emojis. A lot of people really love an emoji. So Greg was really fascinated by this story about how emojis are now being used in court. Why don't you tell us about it?
Well, first of all, I don't call them emojis. I call them emoticons, and that's what I would call them. But, of course, I guess in the courts now they're giving them their proper terminology. But, it's funny because you don't think about it, right? Everybody puts a little smiley face or maybe a sad face or something at the end of a text. And, thumbs up, thumbs down, or, and then there's, combinations that could be, interpreted different ways. But, more recently with the advent of the internet, smartphones, things of that nature, these are starting to be admitted or requested to be admitted into court. And the article basically said, hey, that you can start seeing more of these. And so far, it's like in at least 9 cases, and 6 of them in the last 2 months that they've been admitted as evidence. And I guess just to give you a quick example, there was a Pittsburgh man convicted of a first-degree murder, and he faces a mandatory life sentence for poisoning his wife. So he had told her allegedly that she could get rid of a headache by drinking a serving of creatine, which he had laced with cyanide, and then he punctuated the suggestion with a smiley face emoticon. Now it makes me laugh. I mean, it's not
that
funny.
Is just awful.
It's not funny that he killed his wife, but it's just like
gleeful about it.
A smiley, something about emoticon. The word makes me laugh, but it is like, oh, well, who would do that? Obviously, this guy. So, and then there's several other examples of that, but I mean, things that can be, interpreted different ways. So that's gonna add, I think, to some, as technology progresses and things are admitted into court, it's gonna, certainly make things a little bit more interested in the courtroom to see how these things are interpreted.
Yeah, and it looks like they kind of cut both ways, because they used that one against that guy, I guess, but to show that how nasty he was. He's smiling while he's poisoning his wife. But then we've got another one where we've got a case where a man, he's supposedly convicted of making Facebook threats against his ex-wife, and he's arguing that the threats were not meant to be taken seriously because he shows that one of the violent tirades that he explodes against her on Facebook, he's got a smiley face with the tongue sticking out. So he's trying to say, well, it really wasn't, it might be a violation of the law, but it's not that bad because I was at least doing it while I was smiling.
I was joking with that emoticon.
My tongue was sticking out.
Yeah, that's going to be, it seems like with these examples that it can either help or hurt a case. But, even like...
So they're trying to convict this one guy. They tried to get an indictment of first-degree murder because he had a threatening text message laced with 27 emojis of firearms.
Wow.
So careful what kind of emojis you send out there, folks, because whatever your emoji is, it might well be used against you in court if the comment that you're making is somehow actionable. I mean, it's a question whenever you're introducing evidence in a court, the threshold is always going to be relevance. Say, okay, a prosecutor wants to put in the emoji for whatever reason, the defense lawyer wants to keep it out, or maybe the defense lawyer wants to put it in, the prosecutor wants to keep it out. We object this emoji coming in. On what grounds? Well, it's irrelevant. Well, maybe it is, maybe it isn't. Relevance is always determination. Something that's relevant is going to be, does it tend to make something more true than not? I mean, you're trying to prove something with it. So what are you introducing this emoji for? What was the prosecutor trying to introduce the emoji for in the guy that was poisoning his wife? Not just that because forget the emoji for a minute. They used the text message saying, you can get rid of a headache, honey, by drinking creatine. Of course, he didn't say in it that it was laced with a poison, right? So, what was the relevance of the smiley face to the prosecutor who introduced that? Think about that. What were they trying to prove? Not only was he encouraging her to do it and kill her,
joyfully
doing it.
He knew what he was doing and wanted her to do it.
Which meant that they wanted what for sentencing purposes, because they proved the case against him probably just by the text message itself. They didn't need the emoji.
Right. Now, have you seen a lot of instances now where text messaging is being, of course it's been for a while, but...
there's a text message program that you can download to your laptop or your desktop or whatever. And then you can, and text messages are used all the time. So you download them from your phone, whatever, and put them onto your laptop or desktop or whatever, and you just print them out and you can use them in court. Obviously, you got to authenticate them, but yeah, you're going to use them in court, and they're used all the time. So I had a client came in the other day because so often, if you've got a case where, let's say, a non-consensual sexual encounter is being alleged, and the client comes in and says, well, take a look at these text messages that she sent me before and after. They are not the type of text messages that would be consistent with someone that has just had non-consensual sexual relations with a person. So what do? You download those text messages and you store them, and then the time comes, you use them at trial, either cross-examine or maybe talk the prosecutor into not even charging the case. If at some point say, here, this is what we've got. This person right after they were supposedly sexually assaulted is sending him text messages with hearts, all emojis,
with emojis on them.
Right? And, I love you, and this sort of thing.
If it was just an emoji with hearts, then that could be certainly interpreted.
Yeah, we use text messages. I had a non-consensual sexual assault case not that long ago, actually this last summer, and we used text messages and phone messages. We weren't able. That's the problem with text messages, is so often they're gone. You can't go. You can go back to Verizon and some of these Sprint and so on, and you can go back months and get phone messages, the actual time that the phone call was made and all of that. You cannot go back, though, and get the text message itself from the server. They're gone. You know that, right?
No, because I thought
you can't do it
with the NSA stuff that they're keeping all that information.
No, they really aren't. Like, you can't go subpoena Verizon and say, send me all the text messages that were between Greg Hall and, let's say, somebody else, or in August of 2014. You can't do it. They don't have those anymore.
Wow.
The only way you can use those text messages is if you still have them on your phone, and then you can go download them, just like say somewhere where you can preserve them that way. So you will not be able to get them from Verizon. They only keep them for going back maybe a week.
Wow.
And it's a hard process to get them. You can do it. I've done it before. But you've got to file the notice with them, and you can only do it if you're actually trying to get your own. You can't go subpoena others' text messages. It takes too long. Let's say you subpoenaed the text message. It would by the time the subpoena got served on them, the text messages would be gone. They're very hard to get.
Well, it might be a lot of, I don't know, it might be a server space issue, because it might be expensive to store all that information. Maybe. Because it is the number one form of communication now in the U.S. is text messaging. So I would imagine that it also is coming into play for evidence more and more, and if you have access to that stuff. But a lot of people keep them on their phone forever, so you still have access to it, right? Usually.
Well, they won't stay on your phone forever. They will drop off over time. If you go look back on a string of text messages with, let's say you've got a friend that you text over and over, you'll go back, they'll drop off. Your phone only can keep so many.
So many of them. Yeah.
So, yeah, but they're huge. They really tell the tale, the text messages, and they're used all the time in court now, and will be more and more into the future.
And now, not only text messages, emoticons, so,
Right.
Something to consider.
Well,
sure.
we started out our show by talking about why innocent people plead guilty, and we started it out today with the Mcdonald Trial. And how both Bob and Maureen McDonald just recently gotten their 2-year and 1-year sentences respectively, and didn't have a trial penalty. We talked about the fact that most people and why do innocent people plead guilty? And that's the question that you had today, isn't it? Why do innocent people plead guilty? And as Jed Rakoff states in his article that we've been kind of discussing today, the fact is that there is a somewhat of a trial penalty, according to Judge Rakoff, and because of that, if someone goes to trial in a drug case in America, the chances of he gives an example. Let's just say that at the federal level, Congress has imposed mandatory minimum sentences for narcotics offenses, gun offenses, child pornography offenses, and much else besides. And these mandatory offenses are required to be imposed consecutively. So what happens is prosecutor comes in and says, okay, we're going to charge you with this offense, this offense, this offense, and this offense. They carry mandatory terms and they run consecutively. Now, if you don't want to plead guilty, we're going to charge you with all of them. And if you're convicted, you're going to pull 25 years because there's mandatory sentences, boom, boom, boom. However, if you want to plead guilty, we'll drop this one, we'll drop this one, we'll drop that one, we'll let you plead guilty to this one, and now you're not looking at any mandatory sentence. You can come in, you can plead guilty and do something under the guidelines, cooperate and whatever, and maybe looking at 4 to 5 years instead of 25 years. That's what happens. And the person that says, well, God, I really didn't do any of this. Okay, and the lawyer's saying, well, all right, if you want to go to trial on it, here's your risk. This is your upside. And it's really, really a dangerous. And in state court, you can run into the same thing. Let's say you've got a client that is charged with a home invasion where a gun was used, and there were 4 people in the home that were all robbed at gunpoint in a home invasion. Now, because there's guns involved, you get a 3-year term for the first gun charge. For the successive people, let's say there's 4 people, one gun charge is 3 years. The second, third, and fourth gun charge is 5. And they run consecutive. So let's say your client says, I wasn't there. I wasn't even in with those guys. And they say, well, they say you were. I wasn't. Well, if you want to go to trial and you're convicted, you're going to pull minimum 18 years on the gun charges alone, consecutive. Because you're looking at 3, 5, 5, and 5 for the gun charges. And that's not to mention if the jury wants to find you guilty of the robbery, which carries 5 minimum to life. So what do you do in a case like that? And let's say the prosecutors offered you and said, okay, how about having him come in? I'll drop all but 2 of the gun charges. I'll suspend all the time. You can pull 8 years. What do you do on that? Client's going, I didn't want to do it. I don't want to take that deal. And you say, okay, well, you're going to be pulling 8. If you go to trial, you could get life. And a minimum, you're going to do 18 years on the gun charges. And the smart defendant. And, of course, a lot of times the guy did it. He just thinks that he's got a chance at beating it because he thinks that the guys that are testifying against him are a bunch of, and they're a bunch of thugs, and they maybe he was kind of peripheral to it. And I've had these kinds of cases. Ultimately, if that guy is smart, he's not going to take that case in front of a jury because if he's lit up by that jury, he will be getting 65 years like that fellow we talked about on the Eastern Shore that would turn down the 10-year deal. And this is the thing that so often, as a defense lawyer, if you've got no offer, if the prosecutor has said no offer at all, well, you go, okay, well, then that's easy. We'll go to trial. But as soon as they start making that offer, I had a, but then you've got these other defendants that will just say, I'm not pleading anything. I had a client earlier this year, a very, very, very tough case. And it was a second-degree murder, and prosecutor offered, not going to upgrade to first, let you plead to second, but you got to cooperate, you got to testify, and you got to talk about the other guys. Client says, no, not going to do it. And so he's going to end up going to trial and just taking his chances with it. Because there's some people that say, no, I'm not going to plead. No, I'm not going to cooperate. I'll go and do my time. I've had many people like that. So no, not going to do it. I just soon do my 10 or my 15. I'm not going to snitch. I'm not going to cooperate. I'm just going to go. Sometimes they'll just say, I'll just plead guilty straight up, but I'm not going to testify. I'm not going to cooperate. And that's fine. And you say, okay, you respect that too. There's plenty of clients that just say, I'm not going to testify against my friends, or sometimes it's family members that they might be required to flip on too. And you'll see somebody that might come in and say, okay, if you want to plead guilty, you got to cooperate. You can help yourself. We'll cut you a deal where you can plead guilty, and you're not going to do the mandatory minimums. And then if you cooperate, you can knock that down some more time and this and that. And the guy says, yeah, but once I start to cooperate, I got to tell you everything I know. Well, they're not going to do it, because once they start, they might be talking about a father or a mother or grandfather who's involved in whatever it is that they've been involved in. And they're not going to do it. So I'm not going to start cooperating and then snitching on somebody that I love or know. And so it's a little bit of principle involved there. You got to respect that. You say, fine, I'll do my time. And I've seen clients that could have gotten 1 year, and they ended up getting 10 because they just said, I'm not going to testify. I'm not going to cooperate. I'm not going to turn on other people. So, okay, that's the system. And we've been talking about, mandatory minimum sentences and sentencing in Virginia, both in the state and federal courts. And once again, we come back to the McDonald's, and that they didn't get a trial penalty. They got the 1 year for Maureen and the 2 years for Bob McDonald. And if they just pled guilty straight up to those charges, I'm not sure they would have done any better by getting cooperation. So they went to trial, and there was no penalty, which is unusual.
Which is not the norm.
It's not the norm. No. The statistics are that if you plead guilty, you're going to do a third or less of what you would do if you plead not guilty and go to trial. Now, that's not to say people don't go to trial and get found not guilty. One of the more interesting cases, and I just, we talked about this, Mark Cuban, the Mavericks owner, has just filed a brief on behalf, I don't know if you've been following, but all these insider trading cases in New York that's been going on for the last 5 or 6 years. The United States Attorney up in New York has done all of these there's been 80 insider trading cases in New York. They get convictions on everybody. Well, the rules regarding insider trading are very vague. There's really no definitive law stating exactly what trading on inside information is to prosecute these brokers and these dealers, these guys that are using information to make trades and to do all the stuff. And there's defendant after defendant after defendant. You've been Stephen Cohen, they locked down his whole firm, the SAC and Associates. All these guys have been prosecuted. Well, they went after Mark Cuban. You've been following that?
No.
Mark Cuban spent $20 million. And he's got the money to do it. $20 million defending himself against insider trading charges. He could have settled with the SEC. He could have settled the case. He said, no, I'm not going to settle this case. I'm not going to spend my... And he had the guts to not plead guilty. And he took it to trial, and he was acquitted. Mark Cuban. $20 million he spent. Well, he was just in the paper this week because these traders in New York were convicted this last year of insider trading. They appealed, and the Court of Appeals threw out their convictions. And this has changed everything. Just recently, the whole insider trading federal prosecution thing has changed. In the last 12 months, it's been turned on its head. Because the Court of Appeals has found that the law that these insider traders were convicted on is too vague, and so the Justice Department recently has asked that decision by the Court of Appeals be reviewed, that it's an error, because now all these other convictions are at risk. All these other people that have been convicted are all going to come back in using the same rationale that this Court of Appeals has, and they're going to say that my convictions ought to be tossed, reversed. And so Mark Cuban came in and wrote a brief on behalf, it's called what they call an amicus brief, a friend of the court brief, a friend on the defense side, opposing the prosecution in this case. And what they're asking is that Congress pass a law on insider trading, because there really isn't one. There's really no clear definition. They're using these old statutes, and every time you go to one of these insider trading cases, it seems like the appeal is always that the judge has improperly instructed the jury on this point of law and that point of law, and the reason is because the standard on insider trading is just so vague. And so we've got all these people that are being convicted, and so we've talked about innocent people pleading guilty and why they do it. And here you had, but here was Mark Cuban. Not everybody's got $20 million. And so often that is what it is. It's a lot of times it is a question of money.
Well, yeah. And like, let's say you didn't have any money and you have a court-appointed attorney. Are you going to be confident, even if you are innocent, that that guy can represent you in court, versus maybe an experienced attorney?
Yeah, I mean, the point is that sometimes going to trial is just such a process, and the risk. We've talked about this earlier. You're managing your risk, and when your upside is, and I'm not sure what Mark Cuban's upside was in terms of risk. I don't know if he was actually in danger of going to prison or anything. I don't know really a lot about his case. I did read what he said this week, and when he was ultimately acquitted, and he was offered sweetheart deals to plead guilty to the charges, pay some fines, and go away, and that would have been it. And he refused to do it. And so there are people that will just say, I didn't do it, and I'm not gonna plead guilty to anything that I didn't do. We've got how about this case of Brian Banks? So this is what Jed Rakoff talks about. His lawyer. There's an article about him. Here was a guy. He'd been a high school football star with a scholarship to USC. He serves 5 years in prison for a crime he never committed after accepting a plea bargain under the advisement of his original lawyer. He didn't do it. He did not commit the crime. He had a scholarship to USC, high school football player, did not commit the crime, and later on completely exonerated by DNA evidence. Pled guilty to something he didn't do and did 5 years because his lawyer told him, you should take this deal. And what's a lawyer supposed to tell him when he's looking at an upside of 20 or 30 years? And a lot of times the lawyers don't. When someone is, let's face it, many people do not tell their lawyers the truth. They're going to tell their lawyer they didn't do it. A lawyer might just have been doing this job for years, and guys are coming in saying, I didn't do it, I didn't do it, I didn't do it. Okay. And can you advise them based upon that always? And a lot of times it's really a tough call to make. And, you kind of have to make it like this, like I just said earlier in the show. You have to say, if you did it, then this is a good deal. If you didn't do it, then there's no good deal. If you didn't do it, then nothing is a good deal because you didn't do it. Only you can truly make that decision in this case, because I wasn't there. I wasn't in that room with you and that person or whatever the crime happens to be. And you say you're not guilty of it, and you're saying that they're not telling the truth, and you are. Well, then you've got the right to go to trial and say, I didn't do it. And hopefully the truth will come out. If you're telling me that you didn't do it, well, then the truth will come out at trial. If it doesn't, you've got this very, very high risk situation. And if it does, you could walk right out. I've tried a dozen cases or more just like that, where you go in and you're looking at life and you walk out with complete acquittal. I mean, that's what happens in a lot of cases. People get acquitted. And if, because we've been talking the whole show is if you're going to be found guilty, we got to realize that that's what the jury trial system is all about. That's the whole point of it. That's what the founding fathers had in mind, was that we weren't going to let judges decide these things. We weren't going to let prosecutors and lawyers decide. We were going to let the jury decide. I mean, think about it. Jurors aren't lawyers. So often when you're talking with a client about what's going to happen in the case, and you would think this has all got to do with the law. This has nothing to do with the law. Ask yourself, if you or your mom or your mom's best friend were sitting in the room right now and hearing the story as we've got it, what would they do with it? Would they convict you? This isn't about the lawyer. This isn't lawyering at all. This is common sense. This is the whole jury process. These aren't lawyers sitting on the jury, or people. Take 12 people off the bus going by, stop at the corner, 12 people off. Ask them, run the facts of this case by them as we know it. What would they do with this case? If you think the 12 people off the bus would believe you and not believe the other side, well, then let's go to trial and take your chances. And if you didn't do it, then you should do that. I say this to people all the time. If you didn't do it, don't take the deal. I mean, honestly. So many people go, oh, well, my lawyer said I had to do this. No. And don't always believe that. Oh, my lawyer told me to take this deal. No, most lawyers are going to say, you need to make this decision. When you stand up in front of that judge, we said at the top of the show, did you Talk to your lawyer about this case. Yes. Did your lawyer describe for you what the charges are? Yes. Did your lawyer advise you whether you should plead guilty or not guilty? You discussed this with him. After this discussion, have you decided what you're going to do? I'm going to plead guilty. Are you making this plea of guilty yourself, freely and voluntarily? Yes. You're making this decision. Yes. And the judge will ask you, are you confident that he's making the decision? Is he fully informed, Mr. Yates? Yes. He understands. And in fact, that's what happens. And it's a tragedy, though, that because of the risk, you do have people that will plead guilty to something that they didn't do. We just have example after example after example, don't we? I mean, we have, and we're going to go here. This is Justice for All. I'm George Yates, and thank you for staying with us today. And I want to thank our producer here, Greg Hall, who's been hanging out today, and Dee, who's been our engineer. And this is Justice for All. I'm George Yates. Thank you for joining us today. Come back next Saturday from 2 to 4 for another edition of Justice for All. Have a great day. Stay warm.
CBS News, I'm Deborah Rodriguez. From southern states all the way up to New England, there is no let-up in the nasty winter weather.
I'm Jim Crisula. Things are going from bad to worse across eastern Kentucky after days of heavy snow, record cold, and now an ice storm. The National Guard is being called out in areas that are without power and water service. Several buildings and homes have either fully or partially collapsed. There have now been 8